futures. Always quite volatile at this point in the day, but here they are, down by 16 points. And of course, not forgetting the 207-point gain we saw on the Dow Jones this morning as the lead-in for this market today. Thankfully, we've taken that and run with it this morning and into the afternoon. Looks like there might be some changes on the cards when it comes to discrimination laws, with an attempt to make them more harmonious, is the call this afternoon.
This is an attempt to essentially make the current system more simple, more uniform. It could likely now up the standard out of the current Sex Discrimination Act as well.
The ins and outs we're about to go through with Joydeep of People and Culture Strategies, joining us now from the Sydney studio. Joydeep, good afternoon and thanks for joining us. We talked about being more simple and more uniform, but it sounds like it'll be easier for employees to bring discrimination claims. Is that a concern for business? Just walk us through what's happened today.
Absolutely. Good afternoon, Brooke. Good afternoon, Carson. I think this particular piece of legislation is one of the most significant pieces of legislation to impact Australian workplaces in the last 30, 40 years. I think to put it in context, what we're looking at potentially happening here with this exposure draft is that the current framework whereby at the moment if someone wishes to bring a claim of discrimination or harassment under federal legislation, or indeed under state legislation for that matter, they bear the onus of proof. In other words, they will have to justify and substantiate their allegations that they were subjected to discrimination on the grounds of their sex or race or age or any number of other grounds. What this legislation is proposing to do is to turn that on its head and effectively require the employer or the person against whom the allegations are being made, effectively to disprove those allegations. In other words, you'd be forgiven for saying you're guilty until proven innocent. This is what's referred to as a reverse onus, and it was something that was introduced by the current Labor government as part of the Fair Work Act when they were introducing a particular vehicle or avenue of redress for employees, which are commonly referred to as general protections claims. Now, if you put it in its proper context, you can appreciate that discrimination, harassment, bullying claims have been on the rise. Some very high-profile examples in the last few years, some very headline-grabbing claims for dollar amounts and claims for punitive damages and a range of other things. What a lot of people who practice in this area, myself included, would say is, geez, it would be a very dangerous infrastructure to create if the onus automatically shifts to the person against whom the allegations are made, rather than someone actually having to prove that they were treated unlawfully.
Joydeep, can I just go back to one of your first points about, and it's showing on screen, this being one of the biggest changes to discrimination laws in the last 40 years. There are still areas that are no-go zones, it would seem. For instance, aged care homes run by religious organisations can still discriminate on the basis of religion. Now, why have we not seen a move in that department today?
Yeah, absolutely. I mean, discrimination legislation as it currently stands does allow for certain carve-outs. For example, if someone is dismissed because they can't perform the inherent requirements of their job, that is considered to be a valid form of discrimination, notwithstanding that on its face it is discriminatory. The exclusions that apply and have historically applied to religious institutions and a few other categories will continue to be there. But I think we're not seeing too much change in that space, and understandably some might say, well, why hasn't it gone further? But I think the full import of this legislation in a couple of key areas, the one that I mentioned around the reversing of the onus is going to be significant. Right. And just to give you an example of how that could operate, let's take a situation where an employee feels that the reason they didn't get a pay rise or lost their job was because they rejected their supervisors or managers' sexual advances. Now, under the current law, that person will not merely get away with just alleging those things, they're going to actually have to prove that there was some linkage between the loss of their job and the fact that they were exposed to inappropriate conduct and go into the details and prove all of that. It seems that if this legislation is passed, that individual can point to the fact that they were dismissed and clearly show that they might have been subjected to a detriment, but the onus of showing that it was in no way linked to earlier conduct and effectively the ins and outs of what did or didn't happen will shift very much to the person against whom those allegations are made.
So you're really saying this can give rise to vexatious claims?
Well, I think it's bound to. I don't think there's any question that a reversing of the onus of proof will lead to a significant increase in the number of claims. And to, again, put it in context, it's not as though there's been a shortage of claims that have been brought in the last few years, whether it's for sexual harassment, discrimination, bullying or otherwise.
I know the government said in its rebuttal of that particular concern that the Equal Opportunity Commission is given the ability to dismiss unmeritorious complaints. Is that kind of a credible rebuttal from where you're sitting on that very point?
Absolutely. That's a good thing. I don't think anyone will doubt that the capacity to dismiss those matters that are vexatious is a good initiative. However, you've got to look at the statistical reality of how few complaints actually do get dismissed on the basis that they are frivolous or vexatious. Because the reality, particularly in an area such as sexual harassment, is that only the two people who are involved in the interaction will know what did or didn't happen. And understandably, the Human Rights Commission is going to say, well, it's her word against his word or whatever, and it's for a court to properly test that in accordance with the law.
Assuming not every case that comes before your door is sexual harassment, let's talk as well about the basis on political opinion, which is already covered in the Fair Work Act, Joydeep. So what happens when you get this new umbrella legislation and the Fair Work Act coming together? Which one trumps the other?
Well, I think what this legislation is seeking to do is very much align the protected grounds with the grounds that exist under the Fair Work Act. So the Fair Work Act was a significant step. This discrimination legislation is seeking to maintain parity with those significant developments in the Fair Work Act. So I think from an overall consistency point of view, it's a good thing.
Because you've got things like political opinion, which are covered in the Fair Work Act as grounds for bringing an action, right?
Correct.
And yet will also be, presumably, covered under this legislation, as I understand it.
That's right. So you can bring a general protections claim on the basis of some adverse treatment or action towards you in employment under the Fair Work Act. You'll now be able to do the similar sort of thing under discrimination legislation.
So, to be clear, Joydeep, you're expecting the number of claims to actually rise, given this, what you've almost described, kind of 180 on these laws?
No question, and I think the other thing that will contribute to that is that we're going to move away from a jurisdiction where costs are awarded against an unsuccessful claimant to a jurisdiction where parties bear their own costs. So the skin in the game for the speculative litigant, for want of a better phrase, has been taken away, and I think that's bound to have an impact on business.
Briefly, finally, you said this is an exposure draft. What are the likely chances of it actually making it through onto the statute book alongside the timeline for a general election?
Look, I think given the work that has gone into this exposure draft, I would expect that it's only a matter of months before it will be tabled, but I think it's fairly safe to assume that if it does get passed, there'll be quite a few constitutional challenges in relation to this piece of legislation and numerous other test cases as well.
Joydeep, it can only mean one thing. You will be back, I'm sure, with us. Thank you for carving out some time to talk today.
Pleasure, Carson. Thanks.
People and Culture's Principal, Joydeep Paul there.
Two people.